Today, we're going to talk about a very common mistake people make. It's also very expensive, or can be, when it comes to their estate or their planning to give to their loved ones after they pass. And I'm going to give a real life example that bothers me. It's something that I've been dealing with and something that is probably was preventable, avoidable, but it wasn't. It didn't get avoided. It didn't get prevented. And it bothers me because the amount of money at stake here is significant and extreme, and it's close to home. Speaking of close to home or far away, let me bring in my co-host, Tony Shore. Tony, we're going to talk estate planning. I'm going to give a real life example of something that's going on in my life and how this very, very common mistake people make when it comes to planning their estate. And I'm going to show you the real life ramifications of it in an example.
Okay.
I'll show you the paperwork. You ready to talk about this?
I am. I'm fascinated by it, and you know that ever since my grandfather's passing, the whole estate planning situation is an attorneys I've dealt with. I've been through the mill with this between taxes on the estate and all this. So I'm actually fascinated by this, and I think the more I learn, the better because there are so many ways to get tripped up and have huge. It can have a huge financial impact one way or the other if you don't understand these things. But what's going on? I mean, we didn't really talk before the show. You just said you've got this story to tell. So
Well,
I'm hearing it along with our listeners.
I'm going to show you the paperwork, and
Okay.
it's an interim accounting of what's happening. So, to give a little backstory, and I'll show you the notes. Um, Basically, I do a lot of work with organizations, local organizations, charities. I help out. I'm on boards and I volunteer my time.
Sure.
And one of these organizations, which is nonprofit, which is key, nonprofit. Okay. One of them recently had a bequest. Someone died and left money to this organization and several others. So naturally, I'm interested to see how this process plays out. Um, 2 years later, the money comes along with this interim accounting report showing what happened, where the money went over the last couple of years. And I want to highlight a few things in here, which I did literally. I highlighted them. Let me share my screen because, wow, okay. Hopefully you could see this. This is the interim accounting, and I've blacked out the names of the organizations and the people involved. But if we look at this, the starting balance is 4,217,000. Big money, right?
Yeah.
For the average retiree, they're not going to have this much money in their estate, but that's not the point. The point is these same things happen to anyone's estate, right? So the objective of this person that died was to leave the money to mostly charities. About 90 to 95% of the money was going to nonprofit charity organizations,
Wow.
right? So I'm front center watching this happen. But there were some disbursements and some distributions that I want to highlight, and I will go through them. First, being on this page at the top, you see it says an invoice for $30,000, and it's titled a statutory 3% probate fee on the first million. We're in Florida, and the statutory rule is on the first million that goes through probate, there's that P word, Tony.
Yep.
One 1 million gets 3% statutory fee, non-negotiable. So what happens? 30% out goes to the lawyer.
So that's to the lawyer. And
To
the
the lawyer.
state dictates that has to happen, that the lawyer gets that money.
It's a statutory fee that's charged
Weird.
to for probate.
Okay.
Now, keep in mind, well, let me go through this and then get to the real crux of this.
And that's
Next page.
3,000. Oh, that's now we're on a different page. Okay.
Next page. 2.5% probate fee on the second 1 million.
Sure.
There's another 25,000 whoosh, gone to the probate attorney. We scroll down. Statutory 2.5% fee on the third million. 25,000 whoosh, gone to
That's
the attorney.
unbelievable.
Oh, just wait. There's more. There's a personal representative fee on there for the lawyer of 12,000 right here.
Where's that?
But
Oh,
but
personal
whatever.
fee. That's not even mandated.
That's, hiring someone to be the personal representative. That happens, whatever. Someone's got to manage the estate. That's fine. I'm not going to get into that.
Sure.
Statutory 2% fee on assets exceeding 3 million. So there's another 25,000 out the window. So all in, we're looking at 105,000 roughly to the lawyer for probate. Now, there's more, but I'm going to stop there for a minute. 105,000 goes out. Well, it's a $4 million estate, so what's the big deal? So on and so forth. But here's my problem with it. This person met with the lawyer years prior and mapped out all the plans. They had powers of attorney, they had a will, they also had a trust. And all of these documents were created in advance, and all of the beneficiaries were named in advance. It wasn't like a scramble probate, who should get what. It was, here's where everything is going, and here are the 4 charities that are getting it, and they're all nonprofit.
But if the trust was set up properly, there shouldn't have been probate fees because there shouldn't have been any probate. You can avoid probate if you'd set up a trust for the library or wherever this is going, whatever board, whatever company, whatever the charity she was leaving it to, right? Local charities, whatever, churches, libraries. If I don't understand how there were probate fees involved or mandatory.
Mistake number 1, Tony. You create a trust,
right,
but you don't put any assets in it.
There you go.
So you have this trust set up to easily distribute assets according to your wishes, but you have this house, you have your bank account, you have your investment account, and you don't name the beneficiary. It's or you don't have it put into the trust. Right?
But isn't that the attorney's job to help make sure that happens so they avoid probate? Because they charge, I'm sure they charged her an arm and a leg to do. I happen to know because my wife and I just created a trust, right? To put our house in and our bank accounts in if something happens to us, so it doesn't have to go through probate. And the attorney, the estate planning attorney, sold us on that based on the fact that this way you're going to avoid probate because probate's very expensive.
We just identified how much it cost in Florida.
Yeah.
Mandatory.
And so I'm sure the attorney at that point, that's how they sell you on a trust. They told her, you need to put this in a trust. But then they have to help facilitate that. Or should.
You would think that the attorney that created the trust, which is the same attorney that's going through the probate, would have said, hey, Tony, let's talk about you, Tony, on the spot. Did your attorney that created that trust for you tell you to then put your house into it?
Yes.
Have you done that yet?
Yes, we're in the process. He actually got the forms and he helped facilitate the whole thing.
So why didn't it happen in this case?
That's what I'm asking. That's the problem. Yeah.
So that's the mistake people make.
Because the attorneys can be snakes. You got to watch out. They sell you on a trust because they can charge you for a trust. They're going to say, hey, for $3,000 or whatever, I'll set up a trust for you so you can avoid probate because probate's really expensive. Okay. They set up the trust. Then they pass. And the attorney never talked to him about funding the trust or helping make sure it happened because they know once that person passes, then they're going to get all the probate court fees on top of their trust fee. That should be illegal. The state should be less worried about making sure the lawyer gets probate money and making that a legal necessity, all those percentages, and more make sure if the attorney set up a trust, they can't also represent or they have to take that out of that. They should change that because attorneys can just get you coming and going then.
You think,
right?
Huh? How about this? How about the attorneys that give you the free will? Hey, we'll give you no charge for the will. Power of attorney, and no, really low fee, $100. I'll give you your will.
Yep.
Why are they doing that? Wills go through probate.
Right.
So the hope is, oh, mom dies.
Yep.
Oh, what do we do? What do we do? Well, I got this will. All right, what do we do now? Well, who wrote the will? Well, let's call up attorney ABC because they wrote the will. Hey, attorney ABC, my mom died. Oh, sorry to hear. What do I do? It says we get the split equally with the 4 kids. Okay, yeah, let me take care of that. We're going to have to go through probate. Whoa, why? Well, because she has a will. That doesn't mean it doesn't go through probate. We still got to prove the will, but I'll do that for you. You could go anywhere, but I know your mom. I helped her write the will. I know it. I know you guys. I've
Yeah.
known you for years. Let me handle the
All
probate.
a will is that's the instruction to the court to the probate court.
Exactly.
Yeah.
But
All wills go through probate if
a trust doesn't go through the probate process if the stuff is in the trust, but in this case it was not.
right.
And there's a disconnect.
And
So
I blame the attorney for that, right?
the attorney could say, hey, I helped you create the trust. I told you what to do. You just didn't do it. So we don't know if this person was just like, I'm not going to bother. Now, there's some cases where you need a trust and you can't put stuff into it, which I want to get to in a moment. But think this through for a minute. If these things were titled properly, beneficiaries listed, it would avoid probate. If it was in the trust, it would avoid probate. And then what? Now, you still have to pay a fee for someone to administer the trust.
Sure.
That could be an executor that charges or not. The lawyer could charge a fee for that. Fine. But would it be the probate fee of $105,000 to just distribute it to charities? But it gets worse, Tony. So that's mistake number one.
I
it
believe
bothers
it gets
me.
Worse.
You've hit it on the head. I'm not throwing names. I took out names because I don't want to throw anyone under the bus. But yeah, this is a problem.
Yeah.
And that's a costly mistake. Now you might say, well, 100,000 on 4 million, big deal. Well, what if it's 400,000 and you're paying 10,000 to someone, right? What's the difference, really?
And there's nothing stopping that attorney from charging more on top of that. That's just the mandated percentage that the attorney.
I think that's the max. That's the max, but they can't. I don't know if they can even charge less. They could probably charge less and say, I'll do it for free. But the mandate, I think it's all required. So that's an easy defense.
Yeah.
I'd love to help you, but this is the state law. So I got to do it. Right. And why else would you put that in the instructions here? Why would you list that as the mandate statute? Even in the later on, it actually has the statute listed. So it's like, don't come at me. Right. Okay. But again, who's here to fight? Charity, right? Charity me. I'm the charity rep for one of the charities.
Mm-hmm.
I say, what's going on here? The charity's going to be like, hey, well, don't look a gift horse in the mouth.
Right.
Right? They're not going to rattle the cages.
Right.
Or will we? Well, that's another question. All right. And then moving on, Tony. It gets worse.
Oh.
Okay. So here's a page. It says in the middle here, proceeds of distribution of tax-deferred Schwab IRA. So a 1.35 million of the 4 was in an IRA. And what's going on here? A net loss of $208,000, $209,000. That is withholdings to our favorite uncle, Uncle Sam. Tell me, Tony, why does the IRS get $209,000 from an IRA when the proceeds are going to charity?
Because they didn't set up a qualified charitable distribution, a QCD.
Well, that's if you're alive and you're over 70. We did a show on that, distributing money to a charity while you're alive.
And so the person should have, but the person who passed, if she wanted the charity to get this money, she couldn't take all this money with her. She wasn't planning on taking the IRA with her. So if you're not planning on taking it with you, why don't you take care of it before you die and give it to the charity via a qualified charitable distribution? And that way it goes directly from the IRA to them. No taxes are owed.
True. However, and that's absolutely right. So watch that show on that for sure.
$200,000 would have been saved, right?
You were right. But what if you just named your charity as the beneficiary on the IRA? What would have happened then? One, it would not have gone through probate. So there goes that 3% fee to the lawyer, because the lawyer's not going to have any say on a direct distribution from an IRA to someone listed as a beneficiary. And two, when you name the charity as the beneficiary is responsible for the taxes. We pay our effective tax rate on this. We're a nonprofit charity. 0 goes to the IRS. All
Okay.
because this person did not name the charity as the beneficiary. They named the trust or no one as the beneficiary. So it went to the trust. The trust pays the taxes at the trust tax rates, which are higher than individuals. And then that money is then proceeds given to the different charities. There's another 200,000 to the IRS.
That's crazy.
Which didn't
And
have
you
to go
know
to
whose
the
fault this
IRS.
is again? Who's to blame for
15% or
that?
whatever it is. Why?
Who's to blame for that?
Why did that happen?
The attorney. The attorney is to blame for that.
Maybe. A financial advisor could also be to blame to say to this, hey, Tony, you know, your IRA, Tony, your IRA, you want that to go to little Johnny, your 3 kids. You want it to split equally on the 3 kids? Well, you could leave it to the trust and then have the trust say split equally. Or you could just leave it to your kids and avoid all the drama, right? And so it's just proper beneficiary designations. Huge mistake people make. And this is a prime example of how costly it could be. No offense to the IRS, Tony, but man, those charities, which was the intent of the person, let's think this through. The person wanted these charities to get the money. They didn't want the IRS to get the money to spend on whatever they're going to spend it on. They wanted these charities to get the money. So, but the IRS took 200,000 off the top for what? So again, a huge mistake by creating a trust to do what you want to do and not putting stuff in it. So now you have to go through probate and then not naming the beneficiaries the way they should be. If you're going to name, so, okay, Tony, you have 3 kids and you have an IRA, your wife has an IRA, and then you have your non-IRA assets. What you would do if you say, I'm going to go, they're all 100,000 each. My wife's IRA is 100,000, my IRA is 100,000, and then we have this joint account worth 100,000. I'm going to give one account to each kid. I'd want to be the kid that doesn't inherit the IRA because I don't have to pay taxes on the non-qualified stuff. So what do you do in that case? You split up the IRA's beneficiary 3 ways so that they can inherit it the way they want to inherit it, not just throw it all in one big pot and then distribute it. So when you're leaving money behind, make sure you're doing it the proper way. Follow your create the procedures. Great. They did the hard part, which is create a trust, create what they wanted. They wrote it down. They hired the lawyer, paid the fee, and then they didn't follow it. They let the government, the lawyer, the probate process figure it out for them instead of just naming the beneficiaries or having stuff into the trust to begin with. It bothers me. We're looking at $300,000, $400,000 of just gone. For what?
Yeah, because it was set up, it wasn't set up
Easily avoidable.
properly. Yeah, it wasn't set up properly, and I like the fact that you point out beneficiary designations within the IRA. I guess you don't have to do the QCD. You could just designate a beneficiary that is a nonprofit. Then there's no taxes. Yeah, that makes sense.
Yeah, whoever the beneficiary is has to pay the taxes. And if the nonprofit's a nonprofit, a true nonprofit, then they don't pay taxes. So, you know, if you're going to leave half your money to charity and half to your children, leave the IRA money to the charities and leave your other money to the children, right? If you have a house that you want to leave to, in this case, they had a house, they had a rental unit. Why not leave that directly to the charity instead of leaving it to the trust to then sell and pay taxes and capital gains and then give it to the charity? Why don't you just leave it to the charity? Let them figure it out because they don't pay tax. Huge, huge mistake. People just don't realize. They don't realize it. And they were all thinking they were doing the right thing. And they still did. I'm not saying that they did anything wrong here, right? If they're leaving money to charity, it's great. But think about the money lost to the attorneys and to the IRS. No offense to attorneys out there also, but man. I
Yeah,
think
because
estate
there are a
planning.
lot of great estate planning attorneys that really their goal is to help their clients end up in the best financial situation and do what's going to end up best for them and their loved ones that they leave behind. My wife and I are working with an attorney that's bending over backwards to make sure we avoid probate and that our trust is funded.
That's
And you
it.
got to work with a financial advisor who's going to make sure you have the proper beneficiary designations based on your goals.
Right. That's it. And talking about taxes and talking about things, because they can't undo this. It's done. It's gone. It's over. There's no fixing it. So easily solved by some pre-planning, but just because you have a trust doesn't mean you're set up properly. You got to make sure you fund it. And just because you say you want to leave charity or whoever in your will, why not go and avoid the probate by naming those beneficiaries directly, if possible? Now, sometimes you can't. We've done shows on the reasons to have a trust, right? You might have an adult child that you got to pass a drug test before they get the money. You can't do that with a beneficiary designation, but you could do that with a trust. So sometimes, it's not always just simple, but in a lot of cases it is, and a lot of drama and a lot of money saved. That's the bottom line. So I'm a little upset about this because it's close to home, but think about the countless number of people that go through this every day, the amount of money being lost through just poor planning or poor executions of plans, just as bad. So, and if the IRS is watching, yeah, I'm not happy that you got that money. I'm really not. So maybe we'll go back and try and fight it and explain, this is going to charity, so, we want our money back, but that'll take another 10 years probably anyway.
Right.
So, Tony, keep going with your trust. Keep making sure you fund it, get your assets into it so that there's no probate, there's no drama. God forbid something happened to you, your kids won't be sitting there paying someone to administer what you've already gone through the hard work of doing. Just, it makes a lot of sense.
Good show, Dan.
I hope everyone enjoyed this, learned it, and learned something from my pain. If you want to talk about it, give me a call, 888-508-5935. Otherwise, we'll catch everyone next week.
All matters discussed in today's show are for informational purposes only.
This show is not investment advice.
Dan Riddle nor Dolphin Financial Group are affiliated or endorsed by any government agency.
Investment advisory services are offered through Dolphin Wealth Management, Inc., a registered investment advisor in the state of Florida.
Insurance products and services are offered through Dolphin Insurance, Inc.
Dolphin Wealth Management, Inc. and Dolphin Insurance, Inc. are affiliated companies doing businesses as Dolphin Financial Group.
You should talk to someone at Dolphin Financial Group before implementing any of these strategies or ideas.